terms of where we are in the market, give you some idea of the volume of disputes and problems we deal with. We were founded in 2017, so I have been doing contentious probate for a lot longer than that, and so nearly 30 years. But I've been doing that in big firms, small firms, and in the end decided that this can only really be done properly if we set up our own law firm that addresses just contentious probate. So that's what we did in 2017, so it's 7 years ago. And we've dealt with over 7,000 client inquiries at various stages. Some of them even phone up before anybody's died. You know, can I make a claim? Who's died? Oh, they're not dead yet. And you're like, well, okay, maybe come back in a couple of years when they have died. So we've had all kinds of stuff coming through. We've got 400 plus different referral sources of work. And what that means is different organisations from different channels. So it's estate administration, law firms, anybody who deals with families who are trying to plan for estates or come across problems and disputes in life or in death. In terms of size, we've got 23 in the firm now, including 18, almost 19 fee earners who are contentious probate specialists. We've had in that 7 years, one of the stats I'm very proud of is we've had 7 IDR babies. So we've had various people having children at that particular period in time, and I've got 4 kids of my own. So one of the other things we did with IDR is set it up so it works for families. So the idea is that we are very flexible in our operation. But we've got 3 offices: Harrogate, Manchester, Bristol. We've got all the badges, bells and whistles, so we're top tier and ranking in the Legal 500. I'm a Hall of Fame lawyer, whatever that means. Chambers, all the things that you'd expect for a top ranking boutique practice We've got 9 of the 18 lawyers who are already ACTAPS accredited, and I was a committee member for years, so ACTAPS is the sort of contentious equivalent of STEP. And then the key thing for us is that we have one area of legal specialism. So everything we do and everything we lean into is all about resolving inheritance disputes or trying to help people avoid inheritance disputes. And then the last stat is a fairly obvious one, is that there are no other. In fact, we're still the only law firm in the country that just does this and nothing else. And the reason behind that is because all the other teams, there's only one that's bigger than ours, they get their work from internal referrals from their non-contentious probate teams. So they already work with their private client teams and get work that way. Our modus operandi is we don't compete with you. So we will actually work with you, and we can actually cross-refer work back into you, so that when people need estate planning sorting out, or they need anything to do with trust and the like, we can pass it back through to you. So in that sense, that hopefully gives you a flavour. My background is maths, physics, computer science, so I'm a bit techie, and I might not apologise for that. I like tech. I like what it can do, the reach it can give, and as a result we've been pretty innovative over the last 7 years. You've got pictures of the various offices, so I quite like Harrogate's the top left one and the bottom right one, so it's a bit sort of New York lofty. So if you're ever up Harrogate way, give us a shout. We've got Betty's tea cakes and all kinds of stuff we can offer as well. And then there's lots of other stuff that's going on in terms of devising ways and means in which we can help the market, the sector that you operate in your day-to-day life, really. So things like the IDRN, for those of you who are not members of the IDR network, that's, if you take anything away from today, it will be that, is please do just register. It's free to do that. I know Lindsay will follow up with a link to that, and it will give you access to lots of information, knowledge, PDF leaflets, guidance, quizzes, all kinds of stuff that's in there that hopefully you'll find interesting. We've also got the IDRU, which is the IDR University. So we have our own bespoke learning platform internally. So one of our growth strategies is that we take our teams, members at a junior end, postgraduate, and we then train them. And that's ongoing all the way through. And in fact, we've got a chap called Stephen Lawson that's joined us, who's on the members of various committees and things. And he actually wrote the book on mental capacity with Professor Jacobi. So we're rolling out a CPD course specific on assessing capacity and how you deal with that on a day-to-day basis. So lots going on. The IDR claim checker I'll talk about a little bit later, which is the one with the big green tick. We are very IT slick in the back office as well, and that's thanks mainly for Lindsay's drive and attention is that HubSpot is it's a well-known CRM system, but for us it means that we can manage inquiries from front right through to end. So we've got a level of data that is pretty impressive, and it helps us make decisions as to how best to support and what parts of the sector are going to need us to get involved a bit more. IDRM is that we are mediatory, so we've got a mediation service that works. IDR Protect is something we're looking at launching in the new year, which is a way of helping people who are drafting wills, people who are estate planning, people like yourselves, who are working with clients to ascertain, assess, and protect against future claims. And that includes things like sort of Lark versus Nugas kind of statements being made automatically at the time a will is being made rather than in reaction to a claim being made. It includes something called the Bank of Mum and Dad, which is an app we're developing to protect against lifetime payments made by parents to kids, which then become the subject matter of disputes that we see, and how can we protect against those disputes. So we're rolling out this kind of protect idea to try and help you protect your clients from claims coming through at the end of it, which does sound a little bit kind of counterintuitive because we are obviously a firm that deals with disputes, but for reasons I'll go into in a minute, we're never going to be short of disputes. So I would like to be able to look back as a legacy point and see what steps did we take, how did we try and contribute towards claims going down and being avoided. And then finally, just two of those, we're a member of the charity ILM, which is the big gold star seal thing. And then there's two more things in there. The BGF, we secured private equity investment last year. So I sold a minority shareholding in the business to a private equity fund, private British Growth Fund. They've provided funding and support for the next couple of years worth of growth and development, most of which is detailed on that page, which includes WillCheck, which is the new B2C website that we've got that links individuals and people directly with a claims assessment tool at no cost to see whether or not they can do something about an inheritance that they feel like they've lost or missed or been defrauded out of. So as you can probably tell, I've talked very fast and gone through that very quickly, but it hopefully gives you a flavour that we've got lots of sort of irons in the fire, lots of things at play. But fundamentally, there are two parts to IDR law. One is we will look after anybody that you refer to as in terms of an inheritance dispute in a way that we would like our own families to look after. And secondly, is that we are working hard to try and find ways at which to reduce the incidence of claims as well. So hopefully that makes some sense. So those are the sort of two remits, generally speaking, that IDR's got. It does mean that we do fit in pretty well with almost everybody in the sector because we don't compete. The bits that we do, you don't do. And that's not unique, is that the people that refer work to us, none of them do contentious probate the way we do. None of them add the extra values that we do. So we're actually able to work with lots and lots of different referrers because, as we know, there is no one source that will give thousands of dispute claims. It's not the way it works, is that the busier you get, for every 100, we'll get 8. So you can imagine you need to be sort of doing 1,000 a week to get to the kind of level that we need week in, week out at our end. So our spread is quite wide. So that hopefully gives you a flavour. I don't know if anyone's got, I'm not expecting any questions on that, but if you've got any questions at any time, just stick your virtual hand up in your box and I'll try and spot it, or take yourself off mute and ask a question. Absolutely fine, happy to do that. If you've got any ideas or you have a look at these things when we send some information through, give us a shout. You might have some ideas that we can work with to improve things for you at your end. You know what your daily job's like. So that's us. Moving on to perhaps the more interesting stuff, really, which is sort of the day-to-day bits of what you do and what we do and how that works. So what I've put there is kind of a list, really, of why there are so many claims and why I believe that there is going to be continued increases going forward. And I suspect if I'd have asked you to list the reasons why you think claims are on the rise, and you'll see that by increased Lark versus Nugas type request letters or claims coming in, or even just read today's wills and probate, you know, literally every new entry or every day there's some other claim that's being reported on, or read the Daily Mail and there's always somebody else complaining about an inheritance that's been stolen. There's no doubt that it's very much front and centre now of family life, which I have to say is nothing new. You know, you can go back into the 1800s, and what was happening back then is the Wills Act, as you know, came out in 1837. So that actually came in before Dickens wrote A Christmas Carol. You know, that'll give you some idea of the ridiculous length of time this thing's been running. And we're all still working on that. We're still working on the Wills Act as being a piece of legislation that still applies. And in the Victorian era, people didn't have cash or assets particularly. It was only the very, very rich that had wills, that wanted to make wills, because they were the only people with anything to give. You know, the vast majority of people didn't have anything, so it wasn't a problem. But then the wills and the probate legislation started to roll in around about the same time as the Wills Act, and it stepped in, but it was really more of a kind of voyeur, kind of watching how the rich live type of situation back then. So the idea that a will should be made a public document back then was really because they were just really interested in knowing what everybody was getting and where it was all going. You know, where does this piece of land? No secret that all the affairs that the Victorian men invariably were having were sort of hidden behind half-secret trusts. And you know, again, they had to do that because they knew the wills were going to become open and the consequences of being found out were significant. So it was an interesting time in the 1800s, culminating, I think, in there were a lot of sort of next generation down who would be able to get cash in advance or run up a tab at the gentleman's club on the basis that, don't worry, when my dad dies, I'll get some money and I'll pay it off. So learning to rely on an inheritance is nothing new. It's the human condition, I think. But what's happened now is, of course, is the value, and it's the second sort of box down on that infographic there, that the fact is, and the reality is, that there is more money stuck at the top end of family wealth than at any time in history. And I certainly in my lifespan, and indeed in yours or even your own children's, is that will not be repeated. The amount of money that's there now is mainly because of the property boom and the baby boomers and the pension values and everything added together means that it's never going to happen again. And that kind of level of wealth hasn't really started in real terms to pass down, but over the next 10, certainly 20 years, it will. And you know, I've given a stat there about 1.3 trillion passing in the next 5 years. Well, I can tell you that the government's changing governments, there'll be no change in inheritance tax, no matter what people say, because the amount of money that they're set to trouser over the next 5 years is going to be enormous. So you're going to find again, you'll see in politics and society, is that will not move. So, you know, that is without doubt a big driver. I think the other drivers are listed there, and I think just pulling out some of the obvious ones, 60% of people still dying without a will. Rules of intestacy, as we know, are almost as archaic as the Wills Act, and don't recognise cavities, don't recognise children of the family or stepchildren. All the problems that, all the facts of life as they now are just simply ignored. And even with very good families who talk to each other, intestacy will throw up disputes, problems, tensions, and cause claims. Likewise, medicine now means that people are living longer and dementia rates are rising. So the problem with people living longer in our profession is that people leave it longer to make a will, or if they have made a will, they decide to make another will and another will and another will. And the number of times we have disputes now where people have made 3, 4, 5 wills because the individual making the wills is trying to, shall we say, control the next generation and how they behave towards them, is definitely on the rise. And people are more litigious. So people now don't have any qualms about going to take advice about whether there's a claim to be made. And I've seen that in my time. When I started doing litigious probate, I did my first one in 1993, so I suspect before a chunk of you were born. But back then, those days, it wasn't called contentious probate. It was just a dispute between the children of a farmer who died and who hadn't made proper provision. Lots of promises, but no provision. And that's grown now to a size where, whilst we're still the only law firm that does it on its own, there are little pockets of teams all over the place. 2 or 3 people here, 2 or 3 people there, mainly servicing their own firm's needs, but nevertheless there's more of them. And blended families, blended families, American phrase, you'll work that out. That's basically second marriage with children from first marriage coming into the second marriage. So you can end up with sort of step siblings and also half siblings. So those blended families, just again a little bit of history, but if you think about it, back in sort of the late 60s, early 70s, that was the first time really when people decided that I can get divorced. Prior to that, you had the odd divorce, but it was very socially excluding. It was something that you didn't do. And moreover, it's something you couldn't do. If you think about it, the Matrimonial Causes Act, which is a piece of legislation that protects and allows a divorcing partner or spouse to make a claim for financial provision. It only came out in 1973. So prior to 1973, particularly as a female, is if there was a divorce, you had no scope to actually make a recovery financially through the courts. So you were totally at the mercy of your spouse who is divorcing you, which is shocking. It's 1973, that's after I was born. I was born in 1970. It's insane that it's that far back. And in fact, the Inheritance Act of 1975, you probably come across the 75 Act, is something very similar in death, is that prior to that, prior to 75, there was no provision. So if somebody left in a will for, or failed to make provision for a partner, then there was nothing you could do about it prior to 75. And you've got a lot to thank a chap called Lord Denning for this, because Lord Denning was a law lord back in the day who was a champion of women who very much tried to force the issue of protective legislation putting in there to make it fair. And thankfully it's moved along since then, not quite as far as it needs to, but it's nevertheless has improved. So if you think back to 1970s, so if you've got 1970s when people are starting to get divorced and remarry, of course that was 40, 50 years ago. So those people have been dying now for the last sort of 5 or 10 years, and they throw up this blended family sort of juxtaposition of everybody, and 2 in 3 families are now blended. My own is blended. I've got my eldest son is from a first marriage, so it's not unusual to have a blended family arrangement. The problem and why the increased number of those causes red flags and claims is because any fracture lines in relationships that exist in life, I can guarantee you, will be deeper and wider in death. So as one of the red flags, and I'll finish this session with a list of the red flags for you to keep an eye out for in your job, but there's no doubt in my mind that blended families as a kind of issue is one to stay alive on, because every single year there will be more blended families for the reasons I've given. There are more people getting married twice and then 3 times, and so on and so forth. And then the final one is the one I've left to one side, because I think it impacts on everyone. This is a new one. This is the one I've seen develop in the last 5 to 10 years. 1 in 3. And what I mean by that is 1 in 3 people are now relying on inheritance. So that's not hoping, that's not expecting, that is reliance. So it means that those 1 in 3 are relying on the inheritance to either fund retirement or discharge debt. It's one or the other. And if they don't receive it, they don't have a plan B very often. These are life-changing amounts of money. They can't get that kind of level of money and funding and pensions and all the rest of it from any other source very often. And as a result, if you don't receive it, they're then left with, my God, I'm going to have to do something about it. And that's what produces the 1 in 4, that box at the bottom. 1 in 4 say that if they don't get what they are relying on, they'll have no choice but to bring a claim. So you can see this all sounds very negative. It's not. It's just this is the reality of where society and why society is going in the direction it's going in, and none of that's got anything to do with lawyers. There are some lawyers who try to jump on the bandwagon with no win, no fee type arrangements. We do very, very few. In fact, we've probably got 2 or 3 running out a caseload of nearly 400 actions going at the moment. So we don't encourage, we encourage early mediatory discussions to try and get to the nub of what the issues are, and let's see if we can fix it. But hopefully that gives you some idea of the why. And what you'll find is with the estates and the people you talk to and the wills that you're checking and the estate planning you put in place, if you won't go far wrong if you look at that list and ask yourself the question, well, are there any exhibiting factors that would lead me to think that they will fall into one of these categories? Now, again, I do summarise this at the end, but that will give you a good direction of travel when if you're looking to see where the signs of trouble are. Does that all make sense? Hopefully that gives you some background. There's lots of talk about individual specific claims, which I'm going to touch upon. Structurally and timing wise, you will see that there are claim types. Why is it important to understand this in the lifetime planning? Well, as part of your lifetime planning, you're already in the privileged position of looking after that smaller proportion of society who wants to take steps to try and make provision for their family and their estates going forward. So with that in mind, it's absolutely key that as part of your process is that you look to see, I know what you want to do, client, but is there anything that's kind of jumping out at me that I should really box off with you to make sure I get the job right and done properly? Claim types, loosely 4 as they stand. I will circulate these slides so you can have these, but there are 4 types. Effectively, administration disputes are where somebody's died, no problem with the will. They're just the people who they have agreed and have appointed to be the executors and or trustees have run into problems either with each other or with other people or with the taxman or with the beneficiaries, and it gets into a logjam situation where we need to sort of jump in with our size 8s and tell everybody to calm down. Very often remove the people who have been appointed to act as executor and trustee. I see from your literature, I think the way you work at Kinheriot, and again, you'll tell me if I'm wrong, is that there is no positive push, hard drive to get Kinheriot Trust Company Limited appointed as executors or administrators of the estate, is my understanding. Some will want it, and you know, professional trustees and executors, I think, is a very good thing. There are some organisations which will remain nameless because we all know them in our sector who push everybody to go down the professional administration route. There is a place for it, but there's also, you know, if you think about universal wealth, quoting Spider-Man, but with great powers comes great responsibility, is that ultimately he has, actually it was Spider-Man's uncle, wasn't it? Not Spider-Man, sorry. But insofar as what that means is that they had lots of funds under management, and Universal Wealth, you're probably aware, the owners of that ended up in jail, sort of started dipping their hand into it. They couldn't be traced, couldn't be found. And in fact, they went to prison, not because they'd stolen the money, but they went to prison because they were in contempt of court because they wouldn't tell the court where they'd hidden the money. So they still, as far as I'm aware, it's probably still under a rock somewhere, but we've been helping clients unravel the problems of properties being put into protective trusts in a way that doesn't work, and being told that don't worry about this. Never been told, for example, that once you put a property into trust, you don't own it anymore. And as a result, when they came to sell it, they couldn't understand why they couldn't sell it. And worse than that, they couldn't understand why they had a CGT, a capital gains tax bill, at 40% of the entire value of the property. And it turns out they weren't aware. They were sort of hoodwinked into doing this just to get fees. And we have had a couple of successes, notable successes in unraveling those situations. So if you do come across and you ask the question, have you got wills already? And they present you with a Phillips Trust Corporation will, or a Universal Wealth will, or a McClure's will. If you get one of those, give us a shout. There's a bit in the IDRN. There's a fantastic little sort of presentation by one of the clients that we helped, who's broad, very northern, and speaks very northern. It's quite an entertaining sort of 12 minutes that Lindsay had organised and put together. So do, if you get a chance, to have a listen to that. So that's kind of the administration disputes. The other 3 are pretty discreet. although they, as you can imagine, when people are trying to bring a claim, they tend to have a go at everything. Sort of the whole kitchen sink comes at you. Probate claims are claims where you are suggesting that the wills that have been drafted are invalid. So they are invalid. Therefore, they shouldn't stand. Therefore, the prior will, if there is one, should stand, and if not, intestacy rule should apply. Then there's 1975 Acts. They accept that either the will stands or it's an intestacy, but they don't believe that the provisions make reasonable provision for a qualifying person, so they can try and change things. The thing to know about 75 Act claims is it doesn't matter what you do on your wills and your estate planning, you can't prevent that claim being made by a qualifying party. And I'll talk about qualifying parties in a minute, but you can't stop that happening. What you can do is be educated in what a claim actually means. It's one thing to be able to bring a claim, quite another to be able to succeed with that claim. So from my point of view, what you need to know is what are the types of claim, what do I need to be aware of so I can highlight it to the clients and if necessary, take steps. And again, I'll come back to that. Equity claims are basically claims where people argue that it's not fair. A promise was made to me. There's been a series of deathbed gifts as well, which are virtually equity claims as well, where very dramatically somebody sort of sits up on their dying bed and hands over the keys to the house and says, this is yours, you can have it, irrespective of what it says in my will. And then they dramatically croak it and fall back down, and suddenly the person holding the keys says, right, that's mine. And those kind of deathbed gifts, or to give it its Latin title, the donatio mortis causa, DMCs as we call them in the trade, they are definitely going up in terms. And I don't think it's any secret that if you were the 1 in 3 relying and you didn't get an inheritance, the way that they try and work a claim is pretty much from top to bottom as you see it there. They'll look to see whether or not can I knock out the claim. If I can't knock out the claim, can I argue I haven't had enough? If I can't even do that, can I then argue that it's not fair? And that's why it's that particular order that I've set it out. It gets from left to right is the level of impact it has on the wills that you are preparing and drafting across the board. So again, hopefully that just gives you a sort of summary without going into too much detail. What I am going to say though is, in terms of probate claims, this is my maths background, sorry, Venn diagrams. For those that remember, the Venn diagrams are that where they cross over is where they have similar kind of questions and evidence and arguments. So what you've got here is these are the different grounds upon which a will can be overturned. So when you're looking at wills and estate planning, that you can ask yourself, well, okay, am I satisfied they've got mental capacity? Am I going to make sure that I get this thing executed correctly? So Section 9 of the Wills Act 1837 still applies, 2 witnesses, and so on. On undue influence, there's a new bit there, that's I don't know if you can read it, but that says fraudulent calumny, a very Victorian phrase, which means poisoning of the mind. So is there somebody drip in their ear saying, you've got to give this to me unless? Undue influence is probably the most, sorry I keep doing that, is the most commonly alleged reason that we get given at the outset, because everybody says, yeah, they would never have done that, so therefore whoever's now benefiting must have unduly influenced the deceased. So it's very easy to allege, incredibly difficult to prove. Because if you think about undue influence in legal terms is what's called coercion. And what that means is that you have to prove that whoever it is that's signing their will is doing so thinking, if I don't do this, if I don't sign this will, then something bad is going to happen to me. And probably the most vivid example I've ever had of this is that there was a case that we were running a number of years ago now, where he came to us with the defense of a claim in relation to undue influence. And the reason behind that was that he was driving home from work and he knocked over and killed a minor. This girl was only 9 years old. Terrible accident. It was made worse for him because it turned out that the 9-year-old daughter the father of the 9-year-old daughter turns out to be a very high-ranking kind of mafia man who immediately put out basically a kill notice on this man in terms of revenge. And he sold up, disappeared, and left the country, and in fact emerged in Cyprus. And he lived in Cyprus, not telling any of his family or anybody where he was, with a view to trying to stay out the way. And the sister, he was quite wealthy, so he banked his money and lived in Cyprus. Didn't get on particularly with his sister, didn't tell her where he was, and was very aware that this mafia guy was still on the hunt out for him. The sister found him and then travelled out to Cyprus, confronted him, and basically said, if you don't leave a will, give me everything, then I'm going to tell him where you are. And he did exactly that. So he executed a will, passing everything to her, and then he subsequently died. And his child, who hadn't seen him for a while, then brought a claim for undue influence against the sister. And we were successful in running that particular case. But it gives you an idea of how extreme it needs to be able to show coercion. We were able to show that he had no relationship with his sister. In fact, they didn't go on. There's no way he would prefer her over them. And then by the time then we got down to the evidence, and we got evidence to see he'd left a note and a video testimony of what she'd done. So we were able to overturn the will. But it gives you again some idea of the lengths of evidence that we have to go to try and make that happen. Fraud and forgery, very dramatic. We've had quite a few of those. People get more and more desperate. The thing about forging a will is that there's only two ways. You either invent both witnesses, or you get two witnesses to be complicit with you. And there's always a fight breaks out, and somebody always breaks cover and confesses. So we've had various cases like that. The fraud tends to be, we've had a lot of overseas kind of witnesses that we've had to track down who were witnesses to wills, and one famous one gave us a statement to say, I was nowhere near them when I executed my signature on there, but they did send me $5,000 in advance to do it, you know. And so it gives you some idea. Again, it all comes down to the evidence. Revocation is the one that you will come across day in, day out. I suppose if I was in the room with you now, I'd be asking you the question, who can tell me how you revoke a will? Should we do it in the chat? Is anybody brave enough to stick something in the chat whilst I'm talking? So how do you revoke a will? Go on, who's going to be first? I can see James typing. It's a race. Go on, James. Hit the return. Destroy it. Absolutely right. So in that sense, you are absolutely right. You can destroy it. You have to have mental capacity to destroy a will. In fact, the same mental capacity you have to make it. So you've got to be able to demonstrate that the person had the capacity to destroy it. So you have plenty of those where it's destroyed by accident. Anybody else? Any other way you can revoke a will? There's two more I can think of immediately. Write a new one. You're absolutely right, Gemma. The only proviso, yep, and Natasha's hit the proviso. It needs to include a revocation clause. So we do get situations sometimes where wills have been drafted without a revocation clause, and that becomes an interpretive nightmare, because both wills then stand, and you've got to work out, do they actually mean to do it? And we get a lot of those. So we get quite a few of where the revocation clause is not quite right, but it's the main reason why that first line is I revoke all previous wills and testamentary disposition. It's why I don't like codicils. My preference is always just do a new will, because codicils can get lost in between wills and revocation. James, bang on. Again, marriage does revoke a will. That's absolutely right. There's a very famous case of Daphne Franks you've probably come across. Daphne actually, we were involved in the initial case. She came to us to start with. My previous firm and my team ran the case to try and get an order from His Honour Judge Jonathan Klein to get the body or the PR rights given to Daphne rather than the husband who married this poor lady who clearly didn't have capacity to marry, and failed. But marriage is one that gets caught out. Probably the most saddest one I've seen with that is a guy who was cohabiting for 30 years and then had a will, left everything for his wife, and then decided at the last minute to make an honest woman of his then subsequent wife, not realising at all that marriage revoked the earlier will, and it caused a problem between his previous kids and her, and it was just a complete nightmare in the end. But absolutely, always ask. You'd be amazed how many people don't, even contentious probate lawyers, don't ask the question or spot that a marriage has taken place. You know, you sit there thinking, well, how do you not know? You can't argue a will if the marriage has then subsequently taken place. You can do a will, as you probably know, there is a clause you can do with marriage that you can put in there that it's in anticipation of marriage. So you can put that clause in there. Again, really, I know some people get desperate, and I never say to people don't make a will, but if you are doing those, I would very quickly say, rather than exposing yourself to potential risks post-marriage, is just take the clause out and re-execute it after you're married. You know, is just do it again, will be my preference. So as you can see, the overlaps and the size of those ovals and circles is deliberate. It shows you the number of claims that we see and how they overlap as a cohort. So mental capacity is by far the biggest area of probate dispute claims. There's no doubt about that. Lack of approval and knowledge is very closely allied to mental capacity and sits with it. And then you can see the smaller ones, your undue influence gets smaller, and then a fraudulent calumny, the poisoning of the mind, gets even smaller still. The one that stands outside that and is bigger than all of them put together almost is the 1975 Act claims, because that you don't need to. The only things you have to establish to be able to bring that claim is that you are a qualifying person, you are a spouse or a cohabitee or a child of family or a financial dependent. That's all you need to prove. And if you can establish that, you can then raise the argument that what you have or haven't received is not reasonable financial provision. And it's really that the Daily Mail has thrown its hands in the air and said, what's the point in doing a will as if you can drive coach and horses through it anytime? Utter nonsense. The 75 Act are claims that are, again, let's go back to the reasoning for the Act coming in, which is why I told you the backstory is, in 1975, this was a fantastic piece of legislation, and I still believe that meritorious claims under the 75 Act save so many people from falling into financial dire need on the death of a loved one than any other act. It's really good, but like most things, it's been abused at the edges, and probably the most common one these days that's talked about is the financial independent adult child situation, where you're advising and they say, look, I've got 4 kids, they're all over 18, I get on with 3 of them, the 4th one I've never seen, really, really, really horrible, don't want to leave anything to them. And the advice you give is what? You say, well, you can leave what you want to who you want. It's the law of the land, you can do that. Can that estranged child bring a claim under the 75 Act? Absolutely, they can bring a claim. Has he got merit? Well, when the Act first came out, the answer would be no, which is financially, you are independent, you're a grown up. It's not France or Spain where you're forced to give to your heirs. You can do what you want with it. The problem lies, of course, is that you bring in the lawyers, and the lawyers then start to argue a case and start to advance it. In fact, the first time I saw this was probably thick end of 15, almost 20 years ago, where there was a chap who died, £3 million estate, 2 daughters. One daughter had married a property developer, and between them had set up a business that was phenomenally successful, more successful than dad, who was a property developer as well. The other daughter had married an accountant. The accountant was a bit of a bad lad, failed, went bankrupt, and they were struggling. This guy, the dad, left, mum had already died, left the entire £3 million estate to Leeds Teaching Hospitals, a charity. And the well-off daughter, or the comfortable daughter, thought that was admirable and was quite happy to do that. And in fact, a wing was named after it. The other daughter had obviously not been as fortunate with the way she'd lived her financial life. And I got hit with a 14-page claim letter by a firm called Mishcon de Ray in London back in the day. saying effectively their argument was this, is that she is somebody who had always believed and relied upon the inheritance coming in, and accordingly she had lived her life expecting that to happen. So she now had, she lived a high life, she had debt, she had credit cards, and it's absolutely right that this should now be paid. I was laughing at the first 3 or 4 pages thinking this is a joke. Got to about page 12 or 13 and I suddenly realized that, goodness me, I can see how if you create enough risk, and that's what this is all about, if you create enough risk that a judge may, in their view, take a view that you should have left something, then you might get home. And where there's risk, there's a deal. So what happened was that there was then a discussion about buying off that risk rather than running it to court. Now, if you're a charity, you'll end up running it to court because you don't want to set a precedent of a judgment that says, yes, you can have it. So on this particular case, it never actually got to court because the daughter bringing the claim sadly had a brain hemorrhage herself and died. So it never got anywhere. But then fast forward to Island Mitson, the case you probably are aware of, is Island Mitson was that same argument. Daughter, estranged, 4 kids of her own, £500,000 estate, gone to charity. She argues that she wants some, cut a long story short, 10 years of legal disputes, 3 appeals going all the way to the Supreme Court. And the first judge gave her 50 grand, 10%. Court of Appeal then rejected and gave 150,000. The next Court of Appeal on the second appeal said, yeah, that's okay. And then the Supreme Court, in now is House of Lords, it was then, turned around and said, no, all of that's nonsense. The judge right at the beginning was okay to give it. We can't overrule that, but she should never get any more. So 10 years and allegedly £1 million worth of fees, and it stayed at 50 grand from start to finish. And the only reason why it ran is because the barrister represented her from the day one on a pro bono. There's a chap called John Collins, who sadly died now, but he was there all the way through. And he turned down an offer from the charity early on, so he was forced to carry on. So again, it's been abused a little bit. What would I say in terms of red flags? You'll come back to that towards the end of the talk. I'm going to finish with a full sort of slide summarising the red flags, but hopefully that gives you the background to it. 75 Act, there's nothing wrong with the Act. What there is wrong with is people having and again, it comes down to reliance, doesn't it? If people are relying on it and they live a lifestyle that means that they have to have it, then they'll find a way to try and argue it. They'll find a lawyer who will try and argue it for them. And then if they're any good at what they do, they'll introduce an element of risk and legal cost. And as a result, this is why most of those are settled through mediation, because nobody particularly wants to go to trial because of the costs involved. And it's impossible to guess what a judge will give. I guess, judges have started to harden, so they've given 0 rewards, which can be reasonable on a couple of cases in the last 12 months. But equally, they still do give awards, and it's a complete guess. So it's almost a little bit like who blinks first and running it through there. But you can help at your end in ways that I'll come back to. So again, I'm trying very hard to just not be too techie, but actually just focus on how these things fit together. But that gives you an idea of the natures of the claim. And then just 2 minutes is evidentially, and this is why your files are important to us, electronic or I don't think you have any hard copy, do you? I think it'll just be electronic, Brian, like us, which is the way it should be. So when I'm looking for evidence, or when the team's looking for evidence to decide whether a claim has got merit or the defence has got merit, or a bit of both usually, is that kind of pearl within a pearl within a pearl within a pearl will give you some idea of the importance and the persuasive nature of that group of evidence. So the will file, do not underestimate how important your file is, because the evidence that we can collate is will file, any contemporaneous documents that are being produced by the person making the will or other people affected, lay witnesses, so they're lay in the sense that they're not professional, they may know them, they may have something to say, and then finally, and only finally, we then end up with medical experts who are basically asked to look at the evidence of the 3 circles below it. Have a look at the witness statements, have a look at the contemporaneous documents, the GP notes, the hospital notes, have a look at the will file. Based on all of that, in your professional opinion, does this person either have capacity or lack knowledge and approval, or is susceptible to coercion? But it comes down to the will file, because the will file, you get to speak to the witness we all want to speak to. We don't get to speak to the main witness, which is the person who's died. So what you put on the will file is really key. And I do an individual session on how to control will file evidence and stuff. More than happy to do a follow-up on that, Natasha. But it's the will file itself is how you record, and that becomes your evidence. And if whoever makes the will file keeps the notes, creates the wills, gives the advice, deals with execution, they are fair game to be asked questions about how you did that. So keeping notes now will make you happier in 8 years' time, because we did a survey on how long it takes between a will being executed and a Larkin Nugis or a claim starting, shall we say, and the average time period was 8 years, which is why I suspect firms that are doing entirely online wills, so no checking, no kind of personal elements to it, most of them only came into being about 8 years ago. So that's why from now on in, you're going to start seeing more claims, I suspect, involving sort of just doing wills and nothing else. Not that I'm saying they're doing it wrong, but what I am saying is that they will be the subject matter. They're the next cohort of will files that are going to be looked at when people are making claims. Again, I'm hoping that makes sense. So that gives you some idea of how it is and how important you are in the chain in life, even though we're looking at this stuff in death. So I've got about 15, 20 minutes to go. So what I'm going to do is, first of all, run through the red flag warnings that I've been promising you for a while. So we'll go through those. And what I'll then follow up with is what we've got at our end that you can access that will help you know and understand a bit more about these red flags that you've got in front of you. So, I mean, I flagged it as family wealth advisors. Any kind of wills or estate planning is whilst you're not investing and the rest of it, you are helping somebody deal with what to do with their wealth, you know, and I find it constantly astonishing that people will work 90 hours a week to amass wealth and then balk at the prospect of doing a will to decide how it should be going and where it should be going on their death. You know, it's death and taxes are the only two certainties in life, quite frankly. So where we stand here is what you see there. So some of these I mentioned before, some of them I'll expand upon. Blended family, the most obvious one that stands out. Take it from me, they will not voluntarily provide you with all the information that you will need in some circumstances. I think you actually have to positively ask, is there anybody else there? Have you been married before? Is there any other? Because what that will do, at the very least, is give you a heads up on who are the people who can bring a 1975 Act claim. Not succeed at it, just bring one. Who can bring one? And once you know that, you can then look at what's happening with them. So if you've got, for example, an extreme example is 3 children, 2 of them are financially independent, and one of them is suffering from either a physical and mental disability, and is cared for either by some kind of residential care provision, or even the parents themselves, is that if there is no provision for them, now granted they may not have capacity, but is there a trust that's been built for them to look after them? If that's not done, then you can guarantee that individual will have a right, A, to bring the claim because they are a child, and B, because there is clearly a financial need and obligation that exists. And in many ways, that's how I would suggest you look at it, is in life, has this person created obligations that these people are relying on? Because if the answer is yes and yes, then I can almost guarantee you there'll be a 75 Act claim that will get home. So if there are people like that, is to highlight it, explain it. What can you do about it? Well, one extreme is, and we get asked to do this fairly regularly, is we get asked the question, Martin, here's the facts, here's the data, here's the financial information, here's the familial tree. What do you think we should leave? How strong is that claim? What is it worth, so that we can then leave enough to make sure that that's disposed of, or advise the client to leave enough so it's disposed of. The other way to do it is to create a discretionary trust that then gives the trustees the power to actually look and say, well, at the point of death, we can look at it and get Martin's advice then. You know, that happens. What do we now need to pay to make sure that we're all right? So that works. But the blended family thing is a big thing. The other thing I would extend that to say, well, actually I'll deal with this a bit further on, is where it's a family-owned business, farming is a great example where most of them don't do wills anyway. Some do. With a family-owned business, don't assume that the asset is just the business and shareholding. You will find it gets a little bit more complicated with cross options and life insurance and all kinds of stuff. But it's quite difficult for family-owned businesses where the key people die, particularly if they die together, the two senior people, to avoid a dispute because the power lines of control sort of mix up with the family members. It's quite rare that all the children are involved in the business. Some are, some aren't. Invariably, there might be spouses of some of the children that are involved in the businesses as well. And it's very much a conversation in life. That's one of those that when they come in, even if it looks simple on paper, I would sit down with colleagues and say, right, okay, how do we shape this up to make sure that there's no claim coming forward? You want to see something basic, like you need to see the partnership agreement. What does that say about death? Because you'll find that shares and finances may well get trumped on death. You might fall into the deceased estate, but his estate is bound by lifetime contracts to do certain things with it. So it's those are the convoluted one that I would definitely refer, sit down and work through carefully. Family falls out's already classic. You know, if anybody's saying you things like, I can't stand so-and-so, or they've not spoken to me for years, they're not getting a penny out of me, you're on notice that there's highly likely there will be some claim in the future. So again, that's all about that red flag's flown up. I need to keep notes that I've spoken about it, I've flagged it up, I've explained that there's a 75 Act that could be brought, and I've proceeded accordingly. So and again, if you're not sure, give us a bell, and I'll talk about contact with us later just to cover up. And to some extent, it's about covering you. I mean, Natasha will say this to you all, it's about covering you and to make sure the firm is doing the right thing by the client, but being able to demonstrate that that's what they've done as well. Child living in the property, classic, is that if the youngest, tends to be the youngest, still living in the property, particularly if they're in their 30s and 40s and they're still living in the property, that is a nailed on 75 Act claim coming your way. So what you need to do is think about, how do I realistically give them time to leave the property? And if I'm leaving it to them, I mean, leave it in the sense of departing. I need to work that out because there's a claim that's coming forward. So again, anything that's got any of these, you can quite happily pick up the phone and speak to us and say, what do you think? Naughty is a reference, sort of tongue in cheek, but you will be amazed at the number of affairs that we find out about on death. And I'm talking multiple affairs. I think the most extreme one is, there's two examples I can give you. One is he was 84 and he had 3 mistresses still on the go at 84. And this guy lived in a little country village, and he would, you know, I was more fascinated than anything. I was saying, how on earth do you keep in contact with 3 mistresses at 80? And he's literally on his mobile walking up and down the village roads, sort of keeping them all and keeping them out of the house because he was still married. And he died, and they all brought claims because he was very wealthy and he had made financial provision for them, whether that be somebody who was paying rents for them, others he was taking on holiday 3 times a year, whatever. There was a financial dependency there, so claims came in. So they don't often volunteer this. Bizarrely, they'll probably tell you more than anyone else. If you ask a direct question, you know, is there anybody I need to know about? Is there any other relationships outside the marriage I need to know about? I have to ask because it's part of my due diligence. There's nothing to stop you doing that. The other example is a bit more extreme, which is an incredibly wealthy guy decided that he would leave something for his mistress, and there was only one mistress, and it was a will, and the will provided that she should receive £1 million within the first 6 months of his death, and that a further 3 million will become available from a trust if the trustees took the view that it was a reasonable thing to do, to provide for her. She came to see me and I assessed her 1975 Act claim as worth about 1.5 million. So it was worth more than the million she was definitely going to get, but less than the 3 million extra under the names of the trust. What we then subsequently found out that this guy had named his wife as the trustee of the trust. So you had the lady who was having the affair as a beneficiary, and she decided that, my client decided that she would take the million rather than risk running for the 1.5, and sit and wait and see what happens. And it was a good decision in the end, because actually the wife died about 3 years later. New trustees came in and she got paid out 2 million quid. So it worked out. But again, it gives you an idea of this. It does make things more convoluted, and these claims tend to have merit, particularly if the people involved tend to be men and they tend to be wealthy who are doing it. Divorce settlements is the one to be super careful about, because divorce settlements are financial settlements I'm talking about here. So if you're assessing finances of somebody who has been divorced, ask to see the financial settlement. So when they provide you with financial details and say, yeah, I've got this house, I've got this, I've got the other, is ask them the question, the singular question you need to ask them is, if you've got a financial settlement in place, does it have a clause in there that prevents any claims under the 1975 Act? And why I would say that is that the 75 Act extends to ex-spouses, unless there is a clause in a financial settlement approved by the court that simply says it is agreed that both parties will not bring a claim against each other under Section 2 of the 1975 Act. There are so many divorce settlements out there where the family lawyers have failed to take that step. And it does mean that when people die, is that we are getting ex-spouses coming forward. Now, they will be able to succeed on getting maintenance payments because they're financially independent, but they're actually getting a second bite at the whole cherry by arguing that reasonable financial provision is more than just the maintenance. Now he's dead, because now he or she is dead, they're worth a lot more. Does that make sense? So it's one that slips under the radar of many, is the divorce settlements. Final two are promises being made. So I've touched on DMCs, the sort of deathbed gifts. Other promises are when again, the farming is probably the best example to give you, is you might well say to a client when you're taking instructions, have you made any promises in relation to your financial assets to anybody to give them on your death? I'd always ask that question, because I think it puts it to bed or it flushes it out. And what I'm looking for here is, we represented a guy called John Suggett up in North Yorkshire. John was born to a farmer, and he was the fourth child of the farmer and farmer's wife. Farmer's wife almost died in childbirth to the third child. She'd had 3 girls in a row, and Dad had said, I am prepared to tarmac your drive if you'll have a go at having another child. So there was some kind of deal struck, and she decided that she would give it a go. Child was born. John was looking after a flock of sheep, age 7, worked all the time, went to agricultural college, and Dad had said to him, leaving over the farm gate one day, when I die, this will all be yours. You're farming it now. We're building you up. I promise this is yours. So effectively, the promise was made. He made a will, unusually, but at the time he made a will, John was 17. So he couldn't receive the farm. The farm was worth 3 million. The estate was worth 4 in total. And what he did is he made a will to Dad that basically had a clause in it saying, I leave the farm, so the 3 million quid, to my eldest daughter, on the understanding that if my eldest daughter agrees that John's a good farmer, then the farm should go to John. Well, you can imagine. He dies, doesn't change his will. John's then in his mid-20s. He's married himself now. He's got 3 kids of his own, all working on the farm. Dad dies. We write to the daughter, his sister, who comes back and says, John is a pants farmer. I'm keeping it all and kept the £4 million. So we ended up having to take action to enforce the promise that had been made. You have 3 limbs to it. Promise being made, we could prove that. Had he relied on that promise? Well, yeah, he had. His entire life would have been based on being a farmer. And did he suffer as a result of that reliance? And short answer is yes, because his career hadn't advanced in any of the directions, hadn't been paid in the first 18 years of his life. It was a bit sketchy, but we got home and we managed to get the 3 million farm back, and she lost the entire remaining £1 million in legal fees, disputes and relocation costs. So lesson learned. And then the final one is avoids will discussion. If they're really sort of hedging and don't want to talk about it, these are the ones that if they've made contact with you to make a will and then simply don't want to talk about the detail, it always puts me on alert, because what you don't want is a situation where you find yourself in the firing line later on for not having asked questions. Just because they're not volunteering information, you need to record the fact that they're not volunteering information. Now, a lot of your stuff I know is electronics. It will come in and they've entered it and the details come in, but don't be shy in asking the questions is what I would say. If there's follow-up questions, ask them. So those in terms of red flags are the ones that when you're talking to people about making will and estate planning is where I would suggest your attention needs to go. You'll see there immediately that's got nothing to do with tax. It's got nothing to do with who actually receives stuff. It's more about what are the things that give rise to claims and getting us involved further down the road. So hopefully that gives you, sort of reaffirms some of the stuff that I'm sure you already know, but also then gives you a highlight as to the whys and a couple of those that maybe you didn't have in the front of your mind when you're talking to people.